The fact that you've found this recording suggests that perhaps one of your eyebrows went up when you came across the decision of Day in Shropshire, and if so, then perhaps like me you find that it hasn't yet come back down. I'd like to explore some of the wrinkles that might lurk within Day in Shropshire through the perspective of a judgment of Lord Briggs in a later decision, the case of Armstead, which was referenced on the card at the start of this recording. Armstead was a case about negligence, damages, insurance law, wildly remote in subject matter from Day in Shropshire, which is a case about local government, planning law, statutory interpretation. But Lord Briggs's point was a general one about the kind of reasoning that had been used in Armstead to reach the decision that found favour with the majority and with which Lord Briggs, in the result, agreed. His concern was about the stepping stones that had been used to reach the conclusion. And in particular, his concern was that one of the stepping stones in the reasoning was a point that had not been the subject of argument. It's a very short judgment. I'll sort of skim through it. It starts at paragraph 75. Towards the end of paragraph 76, he says that he would prefer simply to have relied upon the concession without giving the authority of this court to the proposition of law embedded within it. He says that he doesn't mean to say that he thought the concession was wrong or unwise. At the end of paragraph 77, he says, "My concern is only that because the point went by concession and was therefore common ground between the parties to this appeal, there was no adversarial argument about it." He continues, "One of the enduring strengths of the common law is that when it's developed in the appellate courts, the development is subject to the refiner's fire of adversarial debate and testing before it is endorsed and, in effect, made into what is sometimes called judge-made law." So why does it matter? It matters because of the law of precedent. In England, the ratio of a court's decision is binding, but there are some exceptions to that principle. And one of the exceptions applies to a step of the reasoning which was not argued or went by concession or was simply assumed by the court. That part of the reasoning is not binding, even where it forms part of the ratio decidendi of the decision. Now, the authorities for that proposition were quite late to emerge in English law. You can trace them back, I haven't done an exhaustive exercise, but you can trace them back to a decision of the Privy Council in which I think Lord Diplock gave an interesting speech. That, of course, wasn't part of English law. It became part of English law in about 2001. There was a decision of the Court of Appeal called Kadim, but it has since then been treated as part of English law and is included in a pretty authoritative survey of the authorities and summary of the relevant principles by Lord Justice Lewison in a very recent decision in the Court of Appeal, a case called Zedra Trust Company Jersey Limited and THG plc and others, which is now reported at 2024 Chancery Reports, page 318. I noticed that that case is itself under appeal to the Supreme Court, with a hearing, I think, due to be brought on in February. I don't know whether this aspect of the law of precedent is one of the points that's live in the appeal. If so, it'll be interesting to see what the Supreme Court has to say about it. In a way, I hope that that is up for grabs in the appeal. But why does it matter from the point of view of Day in Shropshire? Well, it matters because 3 points went unargued in Day in Shropshire, each of which was important to the outcome. The first point that went by express agreement was that where a local authority holds land under Section 164 of the Public Health Act 1875, you remember that's the provision that says that the public has a right to go on and use that land for recreational purposes. So where a local authority holds land for that purpose, it's held on a statutory trust. The second point that was agreed was the paradox that the local authority, when it sold land that was subject to Section 164 to a third party, but failed to operate the advertisement procedures in the Local Government Act 1972, acted unlawfully. Yet, the disposition to the third party was valid and effective to confer legal title. That paradox was common ground, and so not examined. And the third point that was common ground, seems to have been common ground, the point seems not to have been argued, was that when the local planning authority was confronted with a planning application to build on the land that had been sold to the purchaser, it should have taken into account the question of whether the development which was proposed would be consistent with the public's rights to use the land under Section 164. In other words, it seems to have been common ground that it was some part of a local planning authority's business to involve itself in questions of law about whether, separately from planning considerations, there might be impediments towards the intended use of the land coming about. Now, I'm sure it's understood that this talk is put out there very much in the spirit of contributing to a debate and a discussion about Day in Shropshire. So I don't offer these points as if they were knockdown arguments, but I do suggest they're points that might be worth reflecting on. I'm going to take them in turn. The first is that it was common ground that land held under Section 164 of the 1875 Act is held on a statutory trust. It's perfectly true. You can find dicta in the authorities, including dicta of high standing. I think there's a decision of the House of Lords on this point, which uses the language of trust to describe the characteristics of land which is held by a local authority under Section 164. But I'd like to suggest that when you look at the context of the decisions, and when you look at the questions that arose for decision in the cases where this concept was introduced into the law, what you find is that the judges were always focused on one particular aspect of the law of trusts. The aspect they were focused on was that the trustee does not hold trust property for his own benefit. The trustee gets no benefit from the trust property. The benefit sits with somebody else. In the case of land held under Section 164, it sits with the public that's allowed to go on and walk its dogs, dance around the maypole, whatever the things are that people like to do by way of recreation in the particular locality. That, to take the paradigm case that was singled out by the Supreme Court in its reasoning in Day in Shropshire, arose in a rating context where the question arises very acutely because in the form that rating law took originally, it's since changed, it's become even more complicated than it was back then, but at the time it was crucial to understand not only who owned the land, but who, if anybody, was in beneficial occupation of it, because at the time, unless land had a beneficial occupier, no rates would be payable in relation to it. And so the question that detained the courts was, well, should a local authority pay rates in respect of land held by it under Section 164? The answer was no, and the analogy was drawn with trusts. Like a trust, the authority that holds land under Section 164 gets no benefit itself from its occupation of the land. The land is held for the benefit of other people, so no rates should be paid. The intended analogy, I suggest, was with the well-known exemption from rates of highways. Highways are said to be struck with sterility. Of course, that doesn't mean that the highway is useless. What it means is that the highway has no separate use to which the landowner can put it, and so no rates are payable. The law of trusts, I suggest, was invoked as a metaphor to achieve the same result for public parks as rating law had achieved for highways. And you find a similar you find a similar narrow target being struck at in the other decisions that use the concept of trust in order to describe the characteristics of land held by a local authority under section 164. And so, for example, the local authority's interest is so slight that when a member of the public goes onto the land, that member of the public is not a trespasser. A member of the public has a sufficient right to be on the land, not to be regarded as a trespasser, despite the title of the local authority. It's that sort of point which is focused on in the authorities. Nothing to do, literally nothing to do, with that aspect of the law of trusts which is about third parties. That aspect of the law of trusts which has the potential to mean that an incoming owner of land might be bound by the same trust incidents as bound the previous trustee owners. And classically, as we all remember, if you want to be exempt from the risk of being bound by a trust, you need to be equity's darling. You need to be the bona fide valuer, the bona fide purchaser for value without notice. And unless you're one of those, there's a high likelihood that you will be bound by whatever equitable interests affected the owner of the land when it was sold to you. So the absence of argument about whether land held under section 164 is actually held under a statutory trust meant that the Supreme Court was not invited to analyse the extent, if any, to which the judges, in using the concept of trust in the decided cases, meant to incorporate the third-party aspects of the law of trust, as well as the question of how much benefit, if any, does a trustee have by reason of holding the legal title to trust property. It might be said that even if what I've said so far is arguable, I still have to deal with the fact that a very closely related statute, the Open Spaces Act 1906, uses the word trust expressly in the statutory language in section 10, where it's talking about land that's very similar to the sort of land that's held under section 164. And so it may be said, well, surely the fact that Parliament has used this word expressly tells us that Parliament intends all the consequences associated with land held on trust to be associated with land held under section 10 in the 1906 Act. So it should be unsurprising to find the same result for land held under section 164 of the 1875 Act. That might be right, but I'd like to suggest that it's perhaps not a silver bullet. It's not necessarily a knockdown point. I suggest that perhaps analytically, really all that happens when you point to the language in section 10 of the 1906 Act is that the same question arises in a different context. Whereas under section 164, the context is that you have to unpick and understand and then apply the judicial gloss that has been laid on section 164 of the 1875 Act. In relation to section 10 of the 1906 Act, you have to do a similar exercise, but by way of statutory interpretation, asking yourself, when Parliament used the word trust, did it intend to incorporate all the incidents of the law of trust, or only some of them, and if only some, then which aspects? Which takes one really not much further, or not to a significantly different place, perhaps, compared with the position when analysing the authorities that relate to section 164 of the 1875 Act and the points that I've already made. Next on my list is that it was common ground that the paradox I described earlier was sound. The paradox is that although the decision to sell the land was unlawful because the authority selling the land didn't comply with the advertisement procedure required by the Local Government Act 1972, despite that unlawfulness, the disposition itself was valid and the purchaser required a legal title. Because it was common ground, the Supreme Court wasn't engaged with the question, well, how does this paradox eventuate in the law? How does it come about? And I'd like to suggest that one way of exposing the problem of this matter not having been considered by the Supreme Court is to illustrate how the point might have been presented to the Supreme Court in a way that invited them to probe this question a little bit. It would have been interesting for the authorities to have asked the Supreme Court to consider whether really the conceptual target for Dr. Day's challenge was the lawfulness of the decision to dispose of the land without having complied with the advertisement prerequisites. In other words, really, Dr. Day should have been focusing his fire on that decision, which of course takes one into the territory of judicial review brought within the statutory time limit, the 3 months that you're allowed. You've got to act promptly, but in any event, within 3 months, the circumstances in which time can be extended are vanishingly few. You've got a very tight time limit in which to apply for judicial review to quash the decision to dispose of the land on the basis that it had been taken unlawfully for want of compliance with the advertisement procedure. Now, if you imagine a hypothetical review, a judicial review brought by Dr. Day in time, there are two situations to consider. One is where he acted so quickly that the council had taken a decision which was unlawful and the disposition had not yet taken place. So there'd been a decision to dispose of the land, but no disposition had actually taken place. In that situation, the court may well have taken the view that because of the illegality of the decision, it would injunct the disposition to the third party. It would prevent that from happening, which it was unlawful should happen. But there's another possibility, which is that Dr. Day acted quickly enough to bring himself within the 3 months allowed for commencing judicial review proceedings, but that the disposition itself had taken place. Not only the decision to dispose, but the disposition itself was now completed. And in that situation, I'd like to suggest, perhaps the administrative court looking at this would have discovered that although it could declare that the decision to dispose of the land was unlawful, it was unable to undo the disposition. Why was it unable to undo the disposition? Because of the very words that the Supreme Court was construing in Day and Shropshire, which say that the purchaser is not concerned to inquire with whether the formalities of an advertisement have been satisfied. Now, viewed through the perspective of the Judicial Review Court, that answers the question of, well, what are those words doing? They're directed to a situation in which there has been a timely challenge brought by way of judicial review against the unlawful decision to dispose of land without having advertised the intention to dispose of the land first. That is the context to which those words are directed. And seen in that context, it's perfectly clear what purpose they serve. They're part of the 1972 Act's machinery for enabling local authorities to deal with locally held assets. They're part of machinery to facilitate dispositions, not to complicate them. And it must be remembered, I suggest, that the formality that Parliament required to enable a local authority to liberate Section 164 land of the public's rights of recreation is trivially easy to operate. You just have to advertise. There's nothing more substantial to it than that. We all know, being blunt about it, that a duty of consultation is a thing writ in water. Any competent local authority under a duty to consult can handle any responses without being deflected from the decision it was provisionally minded to make. And so the requirement of advertisement is absolutely trivial. What does it tell us about the way Parliament thinks of land held under Section 164? At one end of the spectrum, the impression seems to have taken hold that Parliament's perception of this land is that it's a precious community asset to be hoarded and protected and only released under the most jealously guarded of circumstances, with everybody, every Tom, Dick and Harry having an opportunity to pitch in and protest and all the rest of it. I have to say, I'd like to suggest that is the exact opposite of the end of the spectrum at which Parliament was aiming with the 1972 Act. On, I suggest, any fair view, by imposing such a slight requirement for a local authority that wants to dispose of land, Parliament is saying, look, this is just a formality you have to go through. The priority here, the policy that the 1972 Act serves in this respect, is to make it easy for local authorities to deal with local assets and to enhance the confidence that third parties can place in decisions and transactions, decisions taken by and transactions entered into by local authorities. So what one sees from this is that perhaps Dr. Day scored a really terrific forensic triumph, because he doesn't seem to have attempted judicial review against the correct conceptual target, the decision which was unlawful by the local authority to have disposed of Section 164 land without advertising the intention to sell. It seems that he was able to wait until long after that had happened, long after the disposition had taken place, without any observance of the crucial time limits that apply to judicial review, and instead attack a completely different decision taken by a different public body when a different question arose, a question about planning permission, and shoehorn into the planning process the question of whether the land in relation to which planning permission was sought, was affected by the public's rights of recreation under Section 164. A kind of forensic triumph to have been able to navigate his way out of what should, I suggest, have been an absolute bright line answer to his whole claim, which is that he left it too late. He left it too late to challenge the decision which was the conceptual target of his complaint. So well done, Dr. Day, but whether that's a positive development for the law is a separate and perhaps more difficult question. Where do these 2 points, leave us, and where do they leave the state of the law? Well, they produce a consequence which I suggest is a bit peculiar. The regime that Parliament enacted was one where land held under Section 164 for the purpose of public recreation can be liberated from those rights, can be liberated from those constraints very easily indeed by a process of advertisement operated by the local authority, which alone is envisaged by the statute as being the person that might own the legal title to the land. So the local authority can get rid of the public's rights of recreation over land very easily by advertising its intention to dispose of the land. But on the basis of the law, as the judges have now stated it, if by mistake or for any reason the advertisement procedure is not followed, but a disposition of the land nevertheless takes place, then the incoming purchaser is bound by the same obligations to allow the public onto the land to enjoy rights of recreation, even though it is not a local authority subject to Section 164, but because it holds the land on a statutory trust to a similar effect. And worse than that, unlike the local authority, it has no power to rid the land of that constraint, because not being a local authority, it cannot operate the provisions for advertisement that are contained in the Local Government Act 1972. So at a stroke, and as an entirely judge-made invention, land which Parliament intended should be subject to a public right of recreation only for so long as the local authority wanted it to remain available for public recreation, must now be available for public recreation indefinitely, permanently, with no machinery being available to eradicate the public's rights of recreation from it. That is a very large consequence to flow from a very small breach, the breach being not having advertised the intention to dispose of the land. And I suggest it's a sufficiently large and I suggest disproportionate consequence to be suggestive and quite strongly suggestive that something has gone wrong with the approach. I'd like to suggest that if the points I've been talking about had been investigated by the Supreme Court, then it might have appeared harder to displace the view which found favour in the Court of Appeal, which was that really Parliament, in enacting the provisions that are in question, Section 164 and the Local Government Act 1972, Parliament, in enacting those provisions, never envisaged a situation in which a third party might become subject to obligations to allow the public onto land for the purposes of recreation, as if it were a local authority. Parliament envisaged only that dispositions would be made after the appropriate advertisement procedure had taken place, but recognising that that might not always happen, and prioritising the right that third parties should have to be able to have confidence in their dealings with local authorities, and prioritising ease of public authorities dealing with local assets, Parliament legislated expressly that if that did not happen, if the advertisement did not happen, then nevertheless the third party should take the land without there being any question of being obliged to allow the public on to do recreational activities on the land. That analysis, I suggest, would have seemed a much more obvious, intuitive and perhaps correct one had the points that went unargued been argued. The third point arises, whatever one thinks about the other two aspects of the matter that I've already spoken about. Remember, it's the fact that the Supreme Court does not seem to have been asked to consider whether it was in fact any part of the business of a local planning authority to inquire into questions of law such as the one that made its way all the way up to the Supreme Court about whether the land that was the subject of the application for planning permission was or was not subject to a public right of recreation under Section 164, and if so, what were the implications of that? It seems not to have been argued that whether or not Dr. Day was right about the way in which Section 164 operates and has the potential to produce consequences for third-party owners of land as well as local authority owners of land, whether or not he was right about that, what business was it of a local planning authority to be involved in that question? I don't want to say much more about it. It's a self-standing point. I'll just emphasise that the conventional view is that local planning authority is not concerned with questions of what the planners call deliverability. That is to say, the planning authority is not typically concerned with whether or not the development for which it grants planning permission is or is not likely to come about in the real world if permission is granted. And the classic example of this is in the context of restrictive covenants. A person might come forward with an application for planning permission on land. We don't even have to own the land. Might come forward with an application for planning permission for development on land that's affected by a restrictive covenant, about which there's a dispute. The dispute might be that one person, the person with the benefit of the covenant, says this covenant means that the land cannot be built on at all. The developer might say, well, no, it doesn't have that meaning. It means that only certain kinds of development can't proceed, and this isn't that kind of development. And so there may be a dispute about whether the development could be restrained by the person who owns the benefit of the restrictive covenant if planning permission were to be granted for the development. But local planning authority has nothing to do with any of that. And there are authorities on this, none of which seems to have been drawn to the attention of the Supreme Court. That there are situations in which deliverability can be relevant in the planning field. There's nothing that I noticed in the decision in Day in Shropshire to suggest that the case was one of those situations. The classic situation where deliverability might be an issue is not really in the context of a particular planning application. It's more usually encountered where a planning authority is promoting a local plan, and it's identified that the local plan needs an allocation of one site for one particular use, say, I don't know, retail or something. So there's a need in the local plan for one retail site, but there are 3 or 4 promoters, each of whom owns a site, and they're all vying with each other to get their site allocated as the site. It's because of the value that would be unlocked flowing from the allocation. When that happens, the planning authority holds what is called a beauty parade. They have to decide, well, which of these candidates is the one that should receive this precious, valuable allocation. One of the factors that can weigh against allocating a site in that situation is if it can be shown that it is less deliverable than the others. So if a site is affected by the existence of restrictive covenants which complicate the route towards deliverability, that may well count against allocating that particular site compared with the other sites. So in that limited sense, deliverability can have a planning relevance. But outside that sphere, the conventional view, supported by authority, is that it's simply no part of a planning authority's business to involve itself in that kind of question. Reflecting on it, one can see why that's the case. Local authority barely has the resources to determine planning applications, let alone to take on the role of investigating potentially complicated, fraught, contentious issues of law, such as the very issue that went all the way up to the Supreme Court about Section 164 in the case of Day in Shropshire. More importantly, perhaps, than that, is I don't want to sound grandiloquent about it, but it's a constitutional question. The proper forum for deciding questions of law, such as Section 164 of the 1875 Act, such as the interpretation of restrictive covenants under different circumstances, is the courts, in some situations the upper tribunal, but certainly not a local planning authority. So, because the matter seems certainly to have gone without argument, certainly without the presentation to the Supreme Court of the authorities on this subject, there has now crept into the law an element of doubt about the extent to which a local planning authority needs to involve itself with this kind of question when it should simply be considering whether there's a planning reason to refuse a grant of planning permission. And it's perhaps a state of affairs that might have been avoided if the matter had been, if the Supreme Court had been invited to look at this matter. As I said towards the beginning of this recording, I offer these thoughts very much in a spirit of contributing to a debate and a discussion about the law, and without meaning to suggest that it must inevitably be the case that any court looking at Day in Shropshire is bound to sort of go along with the breadcrumbs that I've been laying out and anything like that. What I would suggest is that perhaps there are lines of inquiry that might be worth thinking about, and that perhaps there is a little bit more doubt about just how secure Day in Shropshire is as an authority, a little bit more doubt than is perhaps desirable for a decision of the Supreme Court, and perhaps it'd be a good thing if the courts could look at this, perhaps even the Supreme Court look at this and just do an audit to ensure that before too much water passes under the bridge, we really are sure that we want to go down the road that has been charted by the Supreme Court on the basis of reasoning, which does, I suggest, involve a number of stepping stones which are perhaps a little bit less secure than is desirable, and which went unargued. I should say, I'm sure it's understood that listening to me ranting on like this is no substitute for legal advice, and obviously nothing in this recording can or should or may be taken as if it were legal advice. I should also say that, again, I'm sure this is understood, but nothing I've said should be taken to imply any criticism at all of the people who acted for the authorities in resisting the appeal in Day and Shropshire. There may well have been perfectly good reasons for taking the decisions that were taken about what points to run with and what points not to run with. It would have been fascinating to be a fly on the wall listening to the decision-making process. Very often there are considerations that the outsider knows nothing about, so I hope that's well understood. And with that, I will simply say thank you very much for reaching this far.